Hello and Happy New Year. How are you folks? It's me. I'm back. I am happy to be in a new year, happy to join the YouTube fam again. I've been gone for a minute. I understand that. But I am back now and I come bearing news because we have an update in our favorite case. You know, the saga of the killing of Dan Markel and the prosecution of the Adelson family. So this afternoon, I just decided to check the court docket, and I see that there has been a motion for a change of venue. Much anticipated, highly anticipated, but for some reason it never happened with Donna Adelson's former counsel, remember? And everybody was asking, huh, isn't Dan Rashbaum going to file this a motion for a change of venue? Was he going to do it for Charlie? Was he going to do it for Donna? It never happened. Well, Donna, as you all know, has new counsel. They are on top of it. They are doing what they can to save their client. So we have Miss Jackie Fulford and Mr. Joshua Zellman, who are on the case. That just reminds me of Paw Patrol. My 4-year-old son, he likes watching Paw Patrol. The pups are on the case. Paw Patrol is on the case. So before we get into that really quickly, let me just say hello to the very first people who have jumped on this unscheduled and unplanned live. Hello, Barbara. Hey, good to see you. Good to see you. Top Cat 88. I've missed you guys. I really have missed you. Ms. Demeanor OG. Hello. Hey. I like that I like that the icon that you have. Very cute. Okay, so let's get into this motion for a change of venue because it's something that the community has wondered, is this going to happen? Is it not going to happen? We know how much the Adelsons have not liked Tallahassee, right? Of course, they're from South Florida, and South Florida and Tallahassee, which is in northern Florida, they're like night and day. So we've already gotten a lot of comments about from them about how much they have despised the place. Maybe we know that Miss Wendy Adelson has previously said that she does not like Tallahassee, and that's one of the motives behind her wanting to um, leave Tallahassee all those years ago when she was stuck here because of her ex-husband, Dan Markel, who was subsequently offed in part by her family who wanted to help her get back down to civilization, right? Civilization. I say that in air quotes if you're not listening. So let's go through this motion for a change of venue. It's kind of long, it's 15 pages. So let's get right into it. Share my screen. And all right, can you guys see that? Let me make it a little bigger. There we go. All right. Okay, so this was filed today. Actually, no, it was. It looks like it was filed yesterday at 4:46 p.m., but it showed up in the feed today. So, defendant Donna Adelson, by and through undersigned counsel, pursuant to Rule 3.240, the 6th and 14th Amendments of the United States Constitution and Article 1, Sections 9, 16, and 22 of the Florida Constitution. Wow, they've done their homework. You don't usually see all those citations right here in the preliminary preamble. Move this court for a change of venue, and in support thereof, state as follows. Ms. Adelson was arrested on November 13th, 2023, and on November 15th, 2023, she was indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Now, we're just going to go through a lot of the procedural history, I believe, in uh, the first 2 pages, the first 2.5 pages is just going to be the procedural history. I know if you're here already, you probably already know it, but I'll just read through it quickly just in case there's anybody here who has not been following along or maybe who's forgotten stuff because it's been a little bit quiet in the past several months. So, the trial in this case is scheduled to begin with jury selection on June 3rd, 2025. The undersigned counsel intended to attempt to pick a jury prior to raising this issue. However, on December 31st, 2024, the clerk of court failed to seal the transcript of the September 6, 2024 in-camera hearing on the defendant's motion in limine concerning the testimony of Mrs. Adelson's son. During that hearing, the court ruled that Dr. Rob Adelson's opinion was inadmissible. Wow, this is a lot of information right in here. So, okay, so we know that there was this in-camera hearing. What is an in-camera hearing? It is a hearing where the public is not privy to know what happened. It's a closed-door hearing in judges' chambers. The transcript is sealed, and it is not for public view, really, right? So this hearing that they had in September was concerning Rob Adelson's testimony. And apparently during that hearing, and this is pure supposition, I would assume that it was the prosecution who maybe wanted Rob Adelson to testify, and the defense counsel who was probably arguing that Rob's testimony, which was only going to be opinion based, would not be admissible. That's a whole nother matter. We're not going to get into whether he's an expert witness. I don't know what happened in that hearing, but suffice it to say, if we can assume that what is in this motion is true and accurate, during that hearing, Judge Everett ruled that the son, Dr. Rob Adelson's opinion was inadmissible. Whether or not there would be additional evidence that he could present that would be admissible, I don't know. We don't know. Nobody knows other than whoever was in the hearing that day. Moving on. It is damaging enough that a son is called to testify against his mother. Now, with this information about his inadmissible opinion out there, no one can unring that bell. As a result of the clerk's violation of the court's order concerning sealing of the transcript, Mrs. Adelson has been forced to file this motion sooner. So, what happened was, apparently, the transcript of this in-camera hearing was released to the public. Inadvertently, it shouldn't have been, but it was. Now, I think this happened a few days ago. I may be quick, but I'm not that quick. So I did not see that transcript, but I believe somebody on the interwebs or in these YouTube streets has a download of that. I haven't seen anything about it particularly. I haven't really honestly been following it in the past week or so. So I'm not sure who has that transcript, or if they have done anything with it, if they've published it at all. I don't know. But defense counsel is now saying, since that transcript was made public and people now know what was said in that closed door hearing, the public can no longer, the public can't forget what was said in that hearing, whatever it was. So, statement of facts. Now, these are the facts of the case that we all know, but I'll just go over quickly, just in case you don't remember a fact or somebody's new to the case. On July 18th, 2014, Dan Markell was killed while sitting in his car in the garage of his Tallahassee home. Professor Markell was a prominent law professor at FSU College of Law. Media coverage began almost immediately. The Tallahassee PD began an extensive investigation which involved the FBI and law enforcement officers in multiple jurisdictions. On July 17, 2015, a year later, Tallahassee Police Department released new details in the investigation. On May 25, 2016, Sigfredo Garcia is arrested in the case. Although his report was initially sealed, it was unsealed on June 2nd, 2016. Those documents identified Luis Rivera. Both Garcia and Rivera are indicted. I don't know why this is written in present tense. Sorry, but I should say both Garcia and Rivera were indicted on June 17th, 2016. Additionally, in June 2016, a draft probable cause affidavit identifying Catherine McBanoa, Charlie Adelson, and Donna Adelson is was leaked to the media. On August 29th, 2016, the state released the video of Wendy Adelson's Tallahassee Police Department interview. Garcia and Rivera separately demanded speedy trials, which were set for November 14th, 2016 and October 24th, 2016, respectively. On September 17th, 2016, the investigation and prosecution of Garcia and Rivera were featured on 2020. The footnote says the case has also been featured on subsequent cable television programs, including Dateline, multiple times. After Rivera gave a proffer to the state, Catherine McBanoa was arrested on October 1st, 2016. On October 4th, 2016, Rivera pleaded guilty to second-degree murder, and he was sentenced to 19 years in prison, concurrent with his 12-year sentence in a federal RICO case, separate case from this. Since Rivera's plea, the case has been tried 3 times. 3? Yeah. Garcia was convicted during a joint trial with McBanoa in October 2019. McBanoa was retried and convicted in May 2022. Shortly before McBanoa's second trial, Charlie Adelson was arrested on April 21st, 2022. Charlie was convicted in November 2023. 1 week after Charlie's conviction, Mrs. Adelson was shamefully, I added that, arrested at Miami International Airport, where she did the perp walk through concourse. I don't even know what concourse it was, and then sat stoically in the back of a police car. That's just by adding to it. The media coverage throughout the investigation and trials is overwhelming. Overwhelming. Oh, the trials have all been televised by local and national news. Additionally, the case is the focus of numerous podcasts and blogs. The undersigned counsel is retaining an expert to compile the pretrial publicity to present to this court in support of this motion. I'm just wondering what kind of expert is going to do that. Like, do they need a YouTube, I don't know, channel host or something? Who's going to do that? Questions. Okay, now this is the beginning of their argument. Their first point is that Mrs. Adelson, Donna, has a fundamental right to a fair trial by an impartial jury. We can agree to that, right? Every criminal defendant has a right to be tried by an impartial jury. In essence, the United States Supreme Court has written, the right to jury trial guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. The failure to accord an accused a fair hearing violates even the minimal standards of due process. The 6th and 14th Amendments of the United States Constitution in Article 1, those sections of the Florida Constitution guarantee Mrs. Adelson a fair trial by an impartial jury. Sure. However, Mrs. Adelson cannot receive a fair trial by an impartial jury in Leon County. There we go. They've said it. Tallahassee is nowhere that she wants to be because she can't get a fair trial by an impartial jury in Talon. The pretrial publicity in this case has been so inflammatory, emotional, and pervasive that the Leon County jury pool is now tainted by preconceptions, bias, and prejudice towards Mrs. Adelson. The effects of this publicity make it impossible for a Leon County jury to render a fair verdict based solely on the evidence presented at trial. Unlike many of the trials in which a change of venue was denied, the pretrial publicity in this case includes traditional news as well as blogs and podcasts produced by lawyers and laypersons. This is part of the reason why the court recently granted a change of venue for Brian Koberger in Idaho. Footnote 4. Let's see what that says. Oh, that's just That's just a link to a an order granting Koberger's motion for a change of venue. All right. The second argument is the nature and extent of pretrial publicity in this case warrants a change of venue to protect Mrs. Adelson's rights. The media coverage in this case warrants a change of venue. Not only has the pretrial publicity been extensive, but it has also been highly inflammatory and prejudicial to Mrs. Adelson. In assessing whether pretrial publicity requires a change of venue, the court must determine whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. As the Florida Supreme Court has noted, every trial court in considering a motion for change of venue must liberally resolve in favor of the defendant any doubts as to the ability of the state to furnish a defendant a trial by a fair and impartial jury. Every reasonable precaution should be taken to preserve to a defendant trial by such a jury, and to this end, if there is reasonable basis shown for a change of venue, a motion therefore properly made, should be granted. To determine whether the community's exposure to pretrial publicity warrants a change of venue, the trial court may consider 1. Inflammatory pretrial publicity, or 2. Difficulty in securing an impartial jury. Footnote 6. Footnote 6 says, in other cases, the Florida Supreme Court has used slightly different wording when laying out this test, which suggests a court must consider both prongs. So instead of the or right here, the Florida Supreme Court says you have to consider both prongs. And then they cite some cases in support of that and go on to say, however, in setting this as its test, the Florida Supreme Court cited Murphy versus Florida. Although the Murphy court considered jury voir dire in its assessment of prejudice, it cited to the Rideau versus Louisiana case, a U.S. Supreme Court case, a case in which the court ruled that failure to grant a change of venue violated the defendant's constitutional rights without even considering the voir dire. Thus, although a court may consider jury voir dire in ruling on a change of venue motion, it is not necessary that it do so. As discussed below, a consideration of voir dire would be unhelpful and wasteful in this case. Interesting argument, right? They're saying, don't bother asking the people. Don't bother asking the people that we don't want judging Miss Adelson. Don't ask them. Just take our word for it. Okay, in reviewing a trial court's decision regarding venue, courts examine, quote, any indications in the totality of circumstances that petitioner's trial was not fundamentally fair. The United States Supreme Court and the Florida Supreme Court have considered the following factors in making such assessments: whether the reporting has been factual versus inflammatory or emotional, whether the publicity has included information that would be inadmissible at trial. 3, the existence of pro-prosecution bias. 4, the timing of the publicity relative to the incident and the trial. And 5, the community's hostility toward the defendant. As discussed below, these factors warrant a change of venue in this case. Let's see what they have to say. Because in going through those 5 things really quickly in my head, I'm not sure that I agree. But let's see. The reporting in this case has been inflammatory, emotional, and inaccurate, which distinguishes it from the reporting straight facts in cases in which a change of venue was not required. I'm not going to read that footnote. Even when these stories, quote, report on newly released facts, They take information out of context and use inflammatory language so as to strongly suggest Mrs. Adelson's guilt. There's also been a tremendous amount of prejudicial and inflammatory editorializing in this case. Now, are they going to give examples? Okay, I see a for example here. I'm going to need more than that. All right, let's go back up. Sorry, I'm putting the cart before the horse, but I'm just curious and nosy and impatient. Okay. In addition to including such prejudicial mischaracterizations, which they didn't give any examples of, the pretrial publicity in this case now includes opinions about Mrs. Adelson that this court ruled were inadmissible at trial. The stuff that was said in the in-camera hearing about Rob Adelson, right? As the United States Supreme Court decried in Shepard, the exclusion of such evidence in court is rendered meaningless when news media make it available to the public. Now, has the news media made that transcript available to the public? I don't know. I haven't seen it. Have you guys seen it? Put in the comments below if you've seen coverage about this transcript for the in-camera hearing that was held about Rob Adelson. Let me know, because I haven't seen it. I don't know exactly what it says. And I think the timing between when it was inadvertently published by the clerk and when it was taken down, it wasn't a long time. It wasn't like days. Okay, let's see. What's your name? Trees runs on battery says brother counsel read it. Oh, is that right? All right. Okay. Okay. Surviving the Survivor also read it. Okay. Where have I been? Okay. So thousands of people then. I mean, I don't know how many people Brother Council has, but a lot. Surviving the Survivor also a lot. Thousands of people have seen it then. The question is, how many of those people were from the affected area? I don't know. Okay, for example, in a sealed hearing on September 6, 2024, the court ruled that Rob Adelson's opinion concerning his mother's guilt would be inadmissible. Since the clerk of court violated the court's order sealing the transcript of that hearing, and despite the fact that his opinion is inadmissible at trial, the Tallahassee Democrat, as well as a plethora of podcasters, have now published Rob Adelson's opinion. Ooh, a copy of the article is attached and incorporated as Exhibit A. Y'all, I'm telling you, I'm reading this as I'm seeing this for the first time. I'm seeing this for the first time. Okay. Additionally, so we'll get to it, assuming that they included the exhibits in this filing. Okay. Additionally, this is not wouldn't that, oh, it's a copy of the article. Okay, not a copy of the transcript, but there's probably quotes in there. We'll see. Additionally, this is not a case in which the passage of time has dulled the effects of the pretrial publicity. The intense media focus on this case continues even today because it's not resolved. That's why. There is no suggestion that the media will stop covering this case prior to trial. Can't stop, won't stop. No diddy. No diddy. Rather, if the coverage of the 3 previous trials are any indication, it is likely that the jury selection and trial in this case will continue to attract huge media interest. Thus, this case is distinguishable from cases like Patton versus Yount, where jury selection for Yount's second trial occurred 4 years after the extensive publicity reached its peak. There is not such a gap in time during which potential Leon County jurors will be free from inflammatory and prejudicial media coverage. Were Mrs. Adelson to be tried in Leon County, the inflammatory publicity would be fresh in the jurors' minds. Aside from considering these individual factors, it is important to consider the particularly damaging effects of internet-based publicity in this case. Internet coverage of this case has contributed heavily to the community bias that will prevent Mrs. Adelson from receiving a fair trial by an impartial jury if she is tried in Leon County. Publicity on the internet is particularly harmful for several reasons. Perhaps of most concern is that the internet provides avenues for publication by those who may feel less bound by standards of accuracy, fairness, and objectiveness. And y'all, they quoted a Stanford Law Review article that says, moreover, the internet lacks many of the mechanisms that promote accountability in the institutional media, where journalists' careers may be broken on ethical violations. Bloggers are writing in the wild west of cyberspace. There remains no code of ethics or even an employer to enforce any standards. Basically saying that we can say whatever we want to say with no repercussions, which is not entirely true, I would say. I would not say that that's entirely true. And I would say that most of the stuff, the vast majority of stuff that I've seen, and I think you guys would agree, has been factually based, right? And whenever people are making suppositions, they state that, it's not factually based. I think this probably happened. So, I mean, I don't know. I just don't see how it's any different for people in Leon County rather than people in, say, Orange County, where Orlando is, or Duval County, where Jacksonville is, or Miami-Dade County, where Miami is, or Broward County, where Fort Lauderdale is. Like, the internet allows everybody to get the same information. I don't understand why Leon County, they're saying specifically, cannot produce people that are impartial, a jury that is impartial. All right, their third point is the court should grant a change of venue now as opposed to waiting to attempt to seat a jury. The court should grant Mrs. Adelson's motion for a change of venue now as opposed to waiting to attempt to seat a jury. In Rideau versus Louisiana, a U.S. Supreme Court case, the United States Supreme Court emphasized that in at least the most egregious cases of inflammatory pretrial publicity, it's not necessary to examine the jury voir dire to determine that a defendant's rights have been violated. In that case, the court overturned the defendant's murder conviction, holding that the trial court's refusal to grant a change of venue constituted a denial of due process of law. The court noted that it made its determination that the defendant's constitutional rights had been violated without pausing to examine a particularized transcript of the voir dire examination of the members of the jury. As in Rideau, any effort to try Mrs. Adelson in Leon County, quote, could be but a hollow formality, close quote, given the pretrial publicity to which the Tallahassee community has been exposed. Thus, it is unnecessary to try to seat a jury before ruling on this motion. So are they saying that the Tallahassee community has been more exposed to pretrial publicity than anywhere else? Yet they also say that the entire nation has seen the Dateline, has seen the 2020, and is able to see all the podcasts and blogs and YouTube opinions. So that doesn't equal in my opinion. Even if this court attempted to seat a jury before granting a change of venue, voir dire would not sufficiently protect Mrs. Adelson's constitutional rights. Where media coverage is extraordinarily pervasive and inflammatory, voir dire may not be able to ferret out juror bias. Let's see. The Supreme Court has recognized the limitations of voir dire in highly publicized cases. For example, in Irvin versus Dowd, the United States Supreme Court discounted the claims that potential jurors made that they could be impartial, where so many times admitted prejudice, such a statement of impartiality can be given little weight. In his concurring opinion in Irvin, Justice Frankfurter explained the fundamental problem with relying on voir dire where there had been such intense pretrial publicity in the case. How can fallible men and women reach a disinterested verdict based exclusively on what they heard in court when, before they entered the jury box, their minds were saturated by press and radio for months, preceding by matter designed to establish the guilt of the accused? A conviction so secured obviously constitutes a denial of due process of law in its most rudimentary conception. So, this justice, this quote that they're pulling from, is saying that people who have listened to the radio and seen such pretrial publicity, their minds were saturated by the pretrial publicity that they couldn't even it was impossible for them to enter a jury box um, disinterested, basically impartial. In subsequent cases, the court has reiterated that voir dire is not always sufficient to protect a defendant's constitutional rights. The atmosphere in Tallahassee created by the pretrial publicity in this case is sufficiently inflammatory and prejudiced towards Mrs. Adelson that voir dire would not ensure that she would be tried by an impartial jury. I need to know how. Why? Why are they saying, what is the atmosphere in Tallahassee? They haven't specified that at all. Not to me, at least. Thus, this court need not attempt to select a jury before granting a change of venue. Their fourth argument, granting a change of venue now would promote the efficient use of resources. And that's what we all want, right? Granting a change of venue now would permit an effective use of time and resources. The sooner this court determines where to move this case, the sooner the court, the parties involved, and the county to which this case is moved can make necessary arrangements. Having adequate time to make such preparations will ensure that there are fewer logistical issues in trying this case and that the trial will not need to be delayed for logistical reasons. Furthermore, not only would an attempt to seat a Tallahassee jury in this case be futile, it would be wasteful. At the least, an attempted jury selection in Leon County would cost money and delay the proceedings. However, as the Florida Supreme Court has recognized, the resource costs of improperly denying a change of venue motion can be far worse. Quote, a change of venue may sometimes inconvenience a state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it be determined that the venue should be changed. Conclusion, based on the above, as well as the expert research, which will be presented to the court, Mrs. Adelson's right to a fair trial can only be ensured by changing the venue for the trial. Wherefore, the defendant, Donna S. Adelson, requests that the court grant this motion, change the venue for the trial in her case, and for such other and further relief as is just and proper. Let's see if they attached. Okay, so this is the Tallahassee Democrat Exhibit A. This is the article. Let me go through this real quick and see if there's any quotes. Donna Adelson's former. Okay, so this is a Tallahassee Democrat article that was published on January 10th. On January 10th, titled Dan Markel Murder, What Unsealed Court Docs Say About Donna Adelson's Estranged Son. Donna Adelson's former defense attorney sought to keep out evidence certain statements her estranged son, Robert Adelson, made about her over fears they would severely prejudice the jury and possibly trigger a mistrial. The testimony of Rob Adelson, a state witness, and the oldest of Donna Adelson's 3 children, was the focus of a closed-door hearing at the Leon County Courthouse on September 6, less than 2 weeks before his mom's trial was set to begin in the 2014 murder of Dan Markel. Though the topic of the hearing was unknown at the time, there were indications it involved Rob Adelson, a New York doctor who had a falling out with his parents, his brother Charlie Adelson, and his sister Wendy Adelson after Markel was killed. Charlie Adelson was convicted in the murder in 2023, and Donna Adelson was arrested soon after. A transcript of the hearing, which was briefly unsealed before the scrubbing from the public record, confirmed that the proceedings was held to discuss a sealed defense motion seeking to limit or preclude testimony from Rob Adelson. Participating in the hearing before Leon County Judge Stephen Everett were Donna Adelson's then attorneys, Dan Rashbaum of Miami and Robert Alex Morris of Tallahassee, and Assistant State Attorneys Georgia Kappelman and Sarah Kaplan Dugan. Donna Adelson's trial did not go on as planned. On September 17th, the first day of jury selection, Rashbaum withdrew as her attorney over conflicts involving his previous representation of Charlie Adelson, prompting Everett to postpone the trial. It is now scheduled to begin in June 2025. Everett ordered a recording of the hearing, which was held privately in his chambers, unsealed on December 10th, so Donna Adelson's new attorneys could have it transcribed. The transcript was available on the court's public website for several weeks. For several weeks? It was that long? No way. But was taken down this week. Was it really up for weeks? During the hearing, the lawyers referred to comments Rob Adelson made in an earlier deposition. The Tallahassee Democrat requested a copy of the deposition on Tuesday from the state attorney's office. At the request of prosecutors, Everett ordered the deposition sealed the next day, so nobody gets a copy of that deposition. The hearing was one indication that Rob Adelson could play an important part in his mom's upcoming trial. Here are highlights from the proceedings. Judge, no witness can, quote, just wildly say, I think the defendant's a murderer. During the 20-minute hearing, Rashbaum referred to a number of admissions Donna Adelson made to Rob Adelson, who had been listed as a state witness in previous Markell trials but never called to the stand. Rashbaum said he didn't have a problem with those statements coming into evidence, but he said both opinion testimony and character opinion testimony were not admissible. We think that with this particular witness, given his relationship to the defendant, if there's a misstep here, it would necessitate a mistrial, Rashbaum said. Dugan said she didn't plan to elicit what Everett called just pure opinion testimony from Rob Adelson. So the state was going to get not just opinion testimony from Rob Adelson, they were going to get extra stuff from him. He did provide a lot of opinions in his deposition, she said, but he was also asked, why this? Why that? Why did he bring that to law enforcement's attention or whatever? Why did he bring that to law enforcement's attention? Rob Adelson talked to law enforcement. I won't be asking him any of that on the stand. I won't be asking him his opinion on anything. Everett chimed in, I think it's fairly clear as a matter of law, no witness gets to come in and just wildly say, I think the defendant's a murderer. Rob Adelson said his mom was, quote, very sharp and not, quote, gullible in the deposition. Dugan said she planned to ask Rob Adelson about comments he made in his deposition about whether his mother was gullible or easily fooled, though she couldn't recall his exact words. He said, no, she's very sharp. She's not someone who is gullible or could pull the wool over their eyes easily or something like that, Dugan said. I may ask something like that, which is something he would have personal knowledge of from knowing her. Morris, who Everett later disqualified as Donna Adelson's lawyer over the same conflict issue that prompted Rashbaum's exit, said Rob Adelson's description of her, Donna, was, quote, actually a lot more inflammatory than Dugan's account. It was that there's no person who places their own interests first or something like that than Donna Adelson. Wow. Rashbaum said it isn't admissible. Everett replied that he may be correct as it pertains to the state's case in chief, but he didn't close the door entirely. Depending on what comes out during the defense case, if the door is open, as a matter of rebuttal, if any of the arguments are ignorance, at that point, it's fair game. Wow. Rashbaum suggested the state wanted to get Rob Adelson pontificating about his mom to show jurors he thinks she was part of the murder for hire plot. It's obvious why they're calling this individual, Rashbaum said. They're calling him because they want the jury to know, without him saying it because they're not allowed to, because it's opinion testimony, that he believes his mom is guilty. Markel, wow. So Rashbaum was really arguing against having Rob Adelson testify. They're really worried about Rob, y'all. They really don't want Rob testifying against Donna. Markel, a Florida State law professor, was fatally shot in his garage of his Trescott Drive home on July 18, 2014. The shocking crime that happened as he and his ex-wife, Wendy Adelson, were feuding in court. Aside from Charlie Adelson, 3 others have been convicted in the murder, the 2 hitmen and an accomplice. All right, we know all that. All right, let's talk about this. Part of the defense's sealed motion pertained to what was described by Everett, Judge Everett, as a, quote, racial slur. Though it wasn't clear what was said or who said it. It was the first topic Rashbaum brought up during the hearing, though he said he didn't plan on eliciting that, quote, unless something very unforeseen happens at trial. A racial slur. So somebody said something racist, whether it was Rob Adelson or Donna Adelson. One of them said something. I don't even want to surmise. I would rather not surmise and go there because things could go real left if that comes out. Dugan said she appreciated the defense's discretion in filing that matter under seal. She referenced her own motion that pertained to whether Rob Adelson or any member of the Adelson family would be asked about it. I didn't realize that, Rashbaum said, but it's still the same answer stays, which is we will not ask it of anyone unless something comes up, and then we will come to the court before we do that. Everett said if it did come up, it would need to be handled at sidebar, outside the presence of the jury. Shocker, right? Quote, because of the highly inflammatory nature of putting a racial slur before the jury, I can't imagine a context in which this would occur, Everett said. Wow. Son of a mother. That is something else. So that is Exhibit A to Donna Adelson's motion for a change of venue. They're using Exhibit A to talk about the transcript that was inadvertently uploaded by the clerk in Leon County, saying that the jury in Leon County cannot be impartial at this point because now, in addition to knowing some of the inadmissible things that Robert Adelson, Donna Adelson's oldest son, would say about her, there's also this racial slur that was said by somebody about somebody else or somebody's else. We don't know, but it's out there. I mean, I don't know. I'm not convinced by their motion for a change of venue. I'm not saying it's the worst idea ever, but their motion, I don't see enough evidence to support it. I'm curious to see what the state's reply, what the state's response is going to be to this motion. But as I said, this was filed yesterday, so the state will respond, hopefully in the next week or so. It doesn't look like they set it for a hearing. Hold on one second. Let me just see. Let me just check one thing on the docket. All right, so we have our next case management conference on February 11th at 2:30. So I think it's very likely that this motion will be heard at that point, and probably not before that. So we have that motion, and there is another motion that was filed a few days ago, a handful of days ago. It was Donna Adelson's motion for an in-camera examination of the defense investigator that her prior counsel, Dan Rashbaum, used. If you recall, at the last hearing, Mrs. Fulford, Attorney Fulford, asked of Judge Everett whether they would be allowed to contact the defense investigator that had been working on the case before they were involved with it. And Judge Everett said, because everything turned out to be such a it show, it would really just be cleaner to start over with your own investigator. But in the event that, that's not possible, or you'd rather not, then we would require, or he would require, an in-camera, um, a hearing, an interview of that investigator to see what information he knows. Was he tainted? Was he as tainted by the information that Rashbaum got or could have had as Alex Morris was, for example, or Adam Komisar? Both of those counsel were also removed from the case because of taint, simply because of taint. So this investigator was a part of the defense team, a part of the tainted defense team. So the judge will just want to have a conversation. And I mean, I think it would just be cleaner for them to start over with their own investigator. I don't know what that would do for time and efficiency if they would have to start from scratch. But we don't want to see anything like what we saw already in terms of delay because of conflicts and taint and stuff like that. Let's go to the comments, see what you guys are saying. It's so good to be back. Let me see you guys' comments. All right. So Patty's Playhouse also, it was up for a few days. Yeah, this is talking about the transcript that was inadvertently filed. Yank Canuck, a lot of people never bother with true crime. That's true. I mean, this is a niche. This is a niche community. Not everybody is interested in it. I know plenty of people who have no interest in this at all. And from what I've seen, a lot of people in Tallahassee don't even know about this trial. They don't know about the case. Tallahassee is can be a very transient place just because of the fact that there's like 3 big colleges, schools up there. You have FSU and FAMU and even Tallahassee Community College, I think. So there's people coming in from out of state. There's people coming in from other parts of the state, and there's people also leaving every 6 months from graduation. And it's also the capital of our state. So there's a lot of people coming in from around the state who have no other connection to Tallahassee other than, they're probably a part of the government, but they otherwise don't know anything about the case or anything that happened 10 years ago there. So it's a little far-fetched. It's a little far-fetched, in my opinion, to think that they could not find an impartial jury. How long will this take to decide one way or the other? Like I said, I think that the case management hearing on the 11th, which I guess I'm going to have to schedule a live stream of, I think they're probably going to hear and argue that motion on that day. I don't know. We'll see. We'll see. I don't know how big this is going to get. If there's experts that they want to have testify, they may set it for a special hearing. But we're likely to hear about it on the 11th at least. Not that Judge Everett would decide it on that day, but I think that's the next time that we're likely to hear about it, other than the response. Sorry. So there's usually a motion and then a response to the motion and then a reply to the response. That's technically the wording of of how those pleadings go. Let's see. Crime podcast viewers, yeah, they would definitely be rejected for the jury. Yeah, you're right. Misdemeanor OG says, how can defense claim jurors cannot be objective without meeting them first, right? On the other hand, I was on a jury and everyone was biased on some level, one way or the other. I mean, they can claim that based on that quote that we read, Frankfurter, Justice Frankfurter, when he said, you know, if there's such pervasive media attention, basically, in a particular area, that it just like invades and it gets into everybody's psyche, then I guess they just assume that at that point, um, the jurors in that particular location where that media coverage is would not be able to be impartial. But again, they didn't put in their motion, I don't think, enough facts to support that, you know, that's happened in Tallahassee. Yeah, that's funny. Note to Donna Adelson, not that many people know you or have heard of you. And you know what? You're right. You're absolutely right. We're a community, like we're loud, but we're small. In the grand scheme of everything, very small percentage of the population probably knows of this case. Exactly, Top Cat. That's what I was saying. What exactly has been so inflammatory? You haven't seen anything, and they haven't put anything in their motion. Like you would think that they would put like really inflammatory headlines that they've seen, but nothing. Usually that's what happens, right? So they haven't provided any evidence other than the Tallahassee Democrat article. So let's see. Oh my goodness. Thank you so much. I'm terrible at this. Misdemeanor, thank you so much. Like and subscribe, please. My views are way down. I know. I haven't been on here in a while, but I'm back, y'all. I'm back. Trying to find things to do with you guys. Um, Donna's not famous. Ah, hey Lou. You finally caught Amisha live. Yeah, I mean, hard to catch, right? Because I don't usually schedule them very far in advance. Today I saw this and I was just like, you know what? I might as well just jump right in. Jump right in. So thanks for joining. I appreciate you. You're beautiful. I love it. I love it. Is Harvey Adelson on the witness list, or can he come watch his cute little convict wife? I don't think he's on the witness list. Or if he is, he may be on like list B or something like that. I don't even know if he would come. He would have to come though, right? I think he would have to come. I don't know what Harvey's going on with down in Miami Beach. Maybe I should go look him up or something. Let's see. Trees runs on battery says, I think the inflammatory part they're mentioning is part of the in-camera transcript. There's one part where one of the lawyers says Rob said something like, nobody is more out for their own. Yeah. Nobody's more out for their own interests than Donna. But is that inflammatory? Like, I guess that's opinion testimony, which is probably not allowed. But who knows their mother? Like, a son would know their mother, right? He's known her for, I don't know how old Rob is, but I'm thinking maybe in his 40s, maybe 50s. Man's known her all his life. Um, I just don't see that as an inflammatory statement, you know? I could say some inflammatory statements that I would think might possibly be inflammatory, but I don't want you to crucify me. So just use your imagination. Think of like the worst possible thing, and that would be maybe inflammatory statements. Top Cat's talking about a case. Where's that? Australia or New Zealand or something? I remember reading about that, the mushroom poisoning one where the woman killed 4 people with poisoned beef Wellington. I remember hearing about that. She killed like her husband and her in-laws or something like that. I shouldn't laugh. Um, and her kids just happened to be away for that dinner. Did she kill her pastor too? It's an interesting case. I remember that came out, gosh, my time is off, but it's got to be at least a year now, I think, um, when that one came out. That that would be an interesting case to follow. Can let's see. Can Wendy Adelson's children be subpoenaed when they turn 18 years old, which is around the corner? Mm. That just reminds me of how fast time flies because yeah, the kids are getting older. They're well into their teens now. I don't see them being subpoenaed though. I mean, could they? Anybody can be subpoenaed, but would they? I don't think so. What would they be subpoenaed for? Um, unless it comes to light that maybe admissions have been said along the way, but for anything that they may have witnessed when they were 3 and 4 years old, no, I I don't think George is going to do that. Is that right, Top Cat? Top Cat saying Harvey's not on the witness list, and word is he is unwell. Physically, mentally, emotionally. Hmm. That's sad to hear. I mean, I never want to hear that somebody is unwell, but um, interesting. Hi, Cece. Oh, thank you. Thank you. I appreciate that. uh, mushroom murders. Perhaps she just couldn't cook, misdemeanor OG says. I mean, like, what if you just can't cook? But I think it's the fact that she picked the mushrooms that she maybe knew were poisonous. Top Cat, you're going to have to give a little synopsis of this case. I don't think her preparation of them is what killed them. I think maybe it was the fact that she picked the poisonous mushrooms that killed them. I don't know. Thank you guys. Thanks. I appreciate it. You know, I really go back and forth, and uh, sometimes I'm wondering, like, should I do this? Should I bother doing this? Is it valuable at all? But I appreciate your support. So thank you. If prosecutor is protesting, then Rob said the racial slur. Top Cat says the slur won't come out at all. Top which side wanted the racial slur excluded? If the prosecutor wants it to be excluded, then Rob said it. Prosecution wanted it out. Right. It could have been against strict Jewish religion. It could have been. Mm-hmm. Do I think either motion will be granted? The other motion is the motion to have an in camera with the former investigator. I think that will be granted um, because Judge Everett suggested that that would be the only way to possibly use them to get his approval. And in order to give his approval, he would need to first speak with uh, that investigator. Top Cat, yeah, I think he advised them not to use them, but he also did leave, he sort of did leave the door open for that investigator to come in so that he could determine if any kind of wall was put up or if he was tainted. So we'll see. Oh, girl, I would like to too, Barbara. Wouldn't that be juicy? I'd like, Barbara said, I would like to hear Donna and Harvey's phone calls. I can just imagine. I would love to hear those as well. Hi, T. Kinsella. Long time no see. Happy New Year. Happy New Year. Oh, thank you. All right. Well, that's it for today. So I wanted to go over the venue change of venue motion, which we did. We kind of picked it apart a little bit. I'm leaning towards, this is not enough, but we'll see. We'll see what happens. So I guess that's it, y'all. I'm gonna give you your time back, let you reclaim some time. It is 4:15. I have to go pick up my son. So until the next time, thanks, guys. Thanks for joining. Um, can you do me a little favor and hit the like button on the way out so that people know it's here? Appreciate that. Thank you. All right. Bye.